night an empty shell, which is House Bill 2387. When we last met this afternoon, made an offer to the Senate regarding inserting some language into 2387, several provisions that dealt with the authority of the executive branch. And so the Senate's had a chance.
Please stand by for just a second. There was
Sure.
some interference or...
So we met earlier, and we're now back to consider or to see if the Senate has a position on our offer. Does it sound weird over there?
Thank you very much, Mr. Chairman. We appreciate the offer from the House very much, and the willingness of the House to work on this issue. The Senate does have a response. It's, I hate to go so far as to call it a rejection of the House offer, but if that's what we need to technically do, let's do that. And in its place, then, the Senate counter offer, I will ask the reviser to share now. And the counter, I'll explain for just a moment. Really, the House offer was two parts. One was regarding medical assistance programs and the executive branch, and the second one was Section 2 and religious liberties and protecting people's religious liberties, which, again, is obviously an issue very important to Kansans. So the Senate appreciates the House willing to work on that, and the Senate believes that the House position, as stated in Section 2, is a step in the right direction to protect people's religious liberties. And the change then in the Senate counter to the House proposal is in Section 1. And I will ask the reviser to please explain the Senate counter for new Section 1.
Thank you, Madam Chair. Jason and I were just fighting over this since neither one of us are health revisors. We're a little out of our wheelhouse here. So the provisions here would provide that, except to the extent prohibited by federal law, the Secretary of Health and Environment would be required to continue to administer medical assistance benefits using managed care entities as described in 42 USC Section 1396 U2. And then subsection C would expire the entire section on January 31st of 2023.
Are there any questions for the reviser about what the proposal does? Representative Carmichael.
Thank you, Madam Chair, and I do look forward to an opportunity to address this proposal on its merits. But for now, my questions are to the reviser. As I heard the revisers mention that this is a bit out of their wheelhouse, this is very much out of my wheelhouse, so bear with me. What is 42 USC Section 1396U-2, parent small a, parent numerical 2, parent? What does it provide?
Madam Chair, Representative Carmichael, it's my understanding that that provision of federal law provides that there are certain populations that under federal law cannot be managed under a managed care system. And so these provisions, it's not trying to pull anyone into that managed care system that's not already in there. So it's my understanding that continues to exclude those populations that aren't already covered.
Who are those populations then that are excluded, as I understand it?
That I would have to get you some more information on.
Would it be possible for us to obtain a copy of this federal law so that the members of the committee would have an opportunity to review it and learn for themselves what this balloon amendment means. Would that be permissible, Madam Chair?
Of course.
Okay. Well, I wouldn't want to take action on this proposal until such time as either the revisers can tell me what this statute, federal law is and means, or until I have a chance to lay my own eyes upon it. And I will withhold any further comment until we get to a substantive discussion of the wisdom of this legislation.
Madam Chair, just one clarifying question. The first page of your balloon here obviously has some changes we just talked through. Just want to make sure that everything else that was in 22 RS 4006, well, I think it is on, remains the same as was in the RS. So you're not changing anything in section 2?
Correct. That's correct.
Okay.
Just the balloon there on page 1 in new section 1.
Got it. Thank you.
Senator Haley.
Thank you, Madam Chair. And along the discussion that Representative Carmichael is going, and of course, the committee knows that this entire thread, which I think was originally brought to the attention of another conference committee, that being on 286, has been outside of the scope of what I've been on conference. I know we're working with the Shell here and also a new measure, but I have not really been privy to certainly the House's previous offer that now our offer is countering from the Senate. And it is outside the scope of my delving into the myriad of issues that it raises. I've read a little bit about 286. I don't even know how what the House offered or what we're countering with even dovetails with the discussion into 286, just for full disclosure. And rather than during this close of session impede the progress of it, I'm probably going to request that we have a change in conferees and look to the more learned insight that's been brought for the conferee on behalf of the Senate. And Senator Corson to be assigned to that as well. I think it would just better serve this process to have him. I realize we have to go through the procedurals of it, but just full disclosure, I'm not comfortable trying to weigh in on something that's way outside the realm of my understanding. Thank you.
Thank you, Senator Haley. And HB 2387 and the House proposal that was presented this afternoon at 1:30, which is 22 RS 4006, and then the Senate counter are separate and apart from Senate Bill 286. So if you have, I see in front of you 22 RS 4006 as well as the Senate counter. So it's not related to anything we're doing in Senate Bill 286. If you're comfortable with continuing to be a conferee on this committee.
Well, thank you, Madam Chair, only to say that the concerns or the discussion of the overarching questions that are raised in 286, at least at first blush in my reading of the RS 4006 and our counter, seem to be almost related. There are a broad amount of similarities between those discussions at 286. I think many of the same proponents and opponents to 286 would probably want to weigh in with a more learned on these topics member of the conference committee to understand what exactly has come out. Was there a bill that 406 was there a previous bill that revisers 406 that was in either chamber? If either you know, Madam Chair, or Co-Chair Patton.
Go ahead.
Madam Chair, so section 2 is a language that we've debated quite a lot since early 2020. And so there's been a couple bills that have modified 48.925. The new section 1, I know was in the budget of the House. I'm not sure if there was a standalone. Similar language was in the budget of the House. I don't know. I think there was a standalone bill, but certainly not something that either of our committees dealt with.
Well, again, Madam Chair, Mr. Co-Chair, it's just it's a little bit to do on the fly for me, certainly. And I'm just, I'd have to delve in closer. I have looked a little bit at 286 in the event that Senator Corson was unable to sit in, but I'm outside my understanding. Again, I appreciate how this does work, as Representative Carmichael has pointed with our USC or with the federal code as well. Thank you.
Representative Carmichael.
Thank you. Have we concluded the questions for the reviser? Because I would like to address the merits if we're past the questions for the reviser.
I think if we have no more questions for the reviser, we can go ahead and address the merits.
Okay, thank you. I appreciate that, Madam Chair. What I know about this circumstance principally comes from the Kansas Reflector, an article of March 29 of this year. The Reflector reports that, in fact, this proposal to delay, or in essence, to give the 3 incumbent MCOs a no-bid contract for the next year, first arrived in the form of a bill introduced in the Kansas House. I suppose my question has to be to my colleague, Chairman Patton. Was there such a bill? If so, was it heard? And were there proponents or opponents to that bill when it was brought to committee for presumably a full hearing?
Madam Chair, Representative Carmichael, I am not aware of whether there was a hearing on the bill that was referenced in the Reflector. My understanding is that our Appropriations Committee had discussions on these similar terms, and as you know, it was in the budget that we passed out on the House floor last week.
Whose idea was it to place no bid contracts in favor of the incumbent MCOs into the budget? Who was the proponent of that idea? Whose good idea or bad idea was this?
Madam Chair, Representative Carmichael, I do not serve on appropriations, thank goodness, so I'm not aware.
Is there anybody who can answer that question? Whose idea was this to extend these MCO contracts in a no-bid fashion? Is there anybody who could answer that question for the committee? The silence is deafening. Let me move then to a different question. The Reflector reports that this proposal to extend a no-bid contract to the incumbent MCOs could well lead to the disapproval, if you will, by the federal authorities of the demonstration project that allowed us to have this MCO system in the first instance. That the Center for Medicare and Medicaid Services would be required to approve these no-bid contracts that we're talking about here. Does anyone have any information about whether the Reflector is right, wrong, or otherwise in making that assertion? I take it no one has the answer to that question either. Does anyone know, or has anyone contacted the Center for Medicare and Medicaid Services to investigate whether or not they will or will not approve these no-bid contracts? Should we place them in legislation? Has there been any communication? The silence is deafening. Is there any safety valve on this so that in the event the Center for Medicare and Medicaid Services does not approve the extension through these no-bid contracts, that we will somehow revert to a demonstration project which has been approved? Is there language to protect the entire Medicaid program in Kansas from being vitiated because we made a decision here in this committee without a hearing, without the answers to any questions? Is there any safety valve to make sure that we can continue to receive federal funds to take care of people in need? Is that in here anywhere? I don't think so. In 2014, as I recall, we started down this road of the MCOs. I was here. I remember the fear in this state house as legislators' phones were being tapped as part of a payola, a pay-to-play scandal. Sadly, the same rumors are circulating today that there are subpoenas flying around in this state house. It's a violation of federal law for lobbyists to induce legislators to introduce legislation concerning the Medicaid program with promises of campaign contributions. And that is not an environment that any of us want to be involved with. Now, if somebody can come to me and give me a legitimate and good reason that we ought to extend these contracts in a no-bid fashion, that there is a logical and a good policy reason, that I'll feel a lot better about what we are doing. But in the absence of such an explanation, I have to conclude that we're back to pay-for-play politics here. And I have reason to believe that the federal authorities are already aware of the proposed legislation introduced today by my colleague, Chairman Patton. Think very carefully about what you are doing here, my friends. I don't want my phone tapped. Let me move to something different. When you may recall, and this, by the way, I want to give fair credit not only to the Reflector but the Kansas City Star. Back in August of 2019, some of you may recall that one of the incumbent MCOs, Aetna, which took over the responsibilities of Amerigroup as one of the original three companies, that Aetna was threatened with a 10-day notice that they would be terminated from this program if they didn't immediately take steps to comply with the law and provide the services, and employees of Aetna were in fact fired over it. Is there anyone on this committee that can tell me whether or not Aetna's performance is now up to standard? Has it been evaluated in any fashion so that we can know whether or not it's a good idea to give that MCO a no-bid contract? Do we have any information at all about their performance? I take it we don't. Why? Why would we want to delay a request for proposals so that we can have a fair and open bidding process for some of the largest contracts the state of Kansas lets? Why wouldn't we want to do business in the bright light of day and use the well-accepted governmental procurement process? Why wouldn't we want to get that started right away so that it's a fair and level playing field for Kansas businesses to bid on these contracts? What possible reason could we have to delay that process for a full year unless it was because somebody's palm was getting greased by lobbyists with money. I don't want my name anywhere near this proposal, anywhere near this proposal. So rest assured that we'll go to agree to disagree, and we will have further discussions on the floor of the House concerning how and why this legislation is being brought, the dangers that it accords to our, not only our system of government, but to legislators personally. And we'll have discussions about whether we should favor religious activities over other activities and other matters. Now, I don't want to delay you folks. I know it's supper time. But I don't want to be eating supper at the federal penitentiary someday because of this legislation. Thank you, Madam Chair.
Well, it's a House committee we've called here, so it's okay with me, but yes, go ahead.
Chairman.
I'm sorry.
Come on.
There you go.
I only want to say at this moment, and certainly wouldn't want to impose upon the prior representative's ability to make comments or to speak to the gallery as he has, because I only saw most of the response and his peering out into the audience. But I do want to say at this point in time, I think it's incredibly reckless to discuss pay for play or cast aspersions in regard to people's motivations, particularly within this room. I want to say specifically that that's not the case here. And if his intention was to cast those aspersions within this room, I would hope that with a few moments of reflection, he might decide to reconsider a few of those comments in this particular situation. I'll yield this back in just a moment. But I do want to say for purposes within this room that I don't think comments like that can go without some answer. And normally I don't have any problem at all with folks having their say, listening to that and moving on into the next item. But you said it once and then you carried on in some what I'll call appropriate comments. And then you said it again and then you concluded in that regard. And personally, I take offense to that. I realize that those may be your concerns and those may be your considerations, but in this particular setting and with these folks, I believe it was completely inappropriate to cast those aspersions within this room. I want to tell you, I took offense to it, and I hope with some reflection, those might be considered a little better in the future. Thank you, Mr. Chair.
Representative Carmichael.
Thank you, Mr. Chair. I have strong circumstantial evidence to support what I said, and I have a good faith basis for making those allegations. Now, as to whether or not it is legislators in this room who did that, I don't think so. I think the pay-for-play game is being played at a higher level, and I think some of us may be being used as pawns. And I'm serious about it, Mr. Vice Chair. Very serious, and you should not expect a retraction from this representative.
Any further discussion or comments? Okay. Yeah. Yes, Senator Haley.
Thank you, Chairman Patton. And I didn't realize also too, when addressing Chair of our Judiciary, that I didn't realize that, but I'm ill at ease to even weigh in on this. I have certainly heard, now that I know how to frame the topic, that there are some concerns in the prospect of what's a fifth of our or more of our state's budget and how those contracts are let. That is frankly hall talk that has come to me, irrespective of my involvement on this conference committee. And those concerns have been expressed by legislators, non-legislators, and media alike. It is out there. and it is being circulated that the concerns exist that there may be something untoward being done with a significant part of our state contracts regarding this. Again, I don't want to weigh in as to how we characterize that or how we who are entrusted as good stewards of the contracts we let and the means by which they are come to this. But I did, and maybe it can be characterized differently, but it is out there. And certainly, I guess I could reiterate that I have no knowledge directly of the procedures that these are undertaken. I've been around this process longer than anyone in this room. It's my 28th year. And I remember several times that the integrity has been called into question of the legislature and how we do business. And this is the only time I can remember recently that I've heard about it. And I don't know. I know we've now been handed what 39, section 139.6 U-2A2 of the 42nd U.S. Code does. Haven't had a chance to digest it. Frankly, I'm going to do everything I can to ensure my leadership replaces me during this discussion as soon as we can. We go back in at 7. And I don't know if you're going to end up with an agree to disagree. You're going to reach something on the amendment or the proposed amendment. But David Haley does not want to be involved in this proposed amendment or the underlying one that's been offered until some larger questions that exist in this process are answered, to which I'm not privy, and to which, after 28 years in the legislature, I just frankly don't want my name affiliated with, Mr. Chair.
Good. Any other questions or discussion? Representative Carmichael.
Thank you, Mr. Chair. I should indicate that the reviser was kind enough to retrieve 42 USC 1396U-2 and its subparts. So it is now available to the committee, and I appreciate their assistance.
Not seeing any other discussion, committee. Without even visiting with my side, I do want to take just a little time to read through this information that was passed out, better understand what the Senate's offer is. But to keep this moving forward, my understanding is, Representative Carmichael, you just indicated you wanted to do an agree to disagree on this. So do we want to go ahead and take that step at this point in time? And then we can certainly come back, and if Senator Haley's replaced with someone, we'll have the opportunity to have that discussion before any offer is accepted.
Mr. Chairman, I don't want to do an agree to disagree. I want to find agreement, but at the same time, I know the hour is late, the session is short, and I want to be straight up with you all that I'm not going to sign this come heck or high water. So do as you need to do.
And I hate even asking for one, because I think in the 4 years of being chairman,
Very subtly.
I think we've had one, and it was Senator Wilburn that asked for it at the time. He's not listening, so I can talk about him. It was Senator Wilburn that asked for it. So revisers, remind me how this process even works if we do an agree to disagree.
Mr. Chairman, so we would prepare that agree to disagree. We would, get it to you all for your signatures. It's a House bill, so it would start over in the Senate, and then it would end with you. After that agree to disagree was adopted in both chambers, you guys would reconvene and then continue the conference committee. And then from that point forward, you would only need 4 signatures, 2 from each chamber on the conference committee.
So let's go ahead and proceed with that process. That gives us all a little bit more time to digest this and visit with people as well, but that keeps the process moving forward. Unless, I guess that's my decision, but Madam Chairwoman, do you have?
I do, Mr. Chair. Thank you. Just want to say there's been some comments made in committee here, and I'm not aware of any claims of impropriety or anything in letting bids and things like that. So, and to the extent that persons in this room are implicated by the comments or intended to be in those comments, the representative said they weren't. And just want to make clear that those comments were not directed at those in this room. So thank you.
Very good. Okay, so we will, on House Bill 2387, we'll get an agree to disagree moving forward, and then we'll get back together and have further discussion.
Need a motion, a second, a vote,
Do we?
Are we ready to vote on whether to agree that or accept the agree to disagree, or are we?
I don't know that we need, I think from last time we messed that up. I think we just circulate the paperwork, and assuming, is that correct?
If we all sign it, then
As long as you're comfortable, I mean, you can do whatever you see fit. You don't have to take a motion, second action. You can do it more informally if you want, however you guys see fit.
It's been so long and fortunately so infrequent, I don't know the rule, but it looks to me like we're going to need an agree to disagree, and I think we can agree on that by consensus.
Very good. And that also, again, gives Senator Haley time to have a replacement name. So when we have further discussion. Okay, we'll do that. So Senator, do you want to take over and we'll continue on Senate Bill 286?
sure, thank you. The Senate and House Judiciary Conference Committee on Senate Bill 286 is now what we're moving into. So we have Senator Corson here. The last time we met, I think we were considering some offers. The Senate offers are still on the table for Section 6. And then the offer still with the language regarding the Section C3 of Section 5 that we had presented Wednesday morning, but I understand that I believe the House has continued to consider those and has an offer to make.
Yes, Madam Chair. Thank you. As you know, we've spent a lot of time looking at this language, trying to come up with something that we could agree on, not only agree on, but was good for Kansas, was addressing the concerns we had. I met with the Senate President to hear directly from him what his concerns were. And so we do have an amendment, an offer, I guess I'd like to distribute. I do want to make clear as she passes it out, as it's not listed on what you're going to see, but we also want to keep that the restraint language that was in the crime, where we addressed that concern early on. I want that to be a part of what our offer is going to be. I'm going to explain to you what the intent of this amendment is, and then we might have Natalie walk you through it. It is quite, it's got several balloons, and so it might be a little hard to follow, and so you might need a little time to read through that, but I certainly want Natalie to talk through it with us. What we've heard both in committee and and the public is that we don't want to give healthcare providers additional liability protections if we're not going to, in exchange, make them provide services to those with or without the COVID vaccine. And that's, I guess I'll pause until everyone grabs their papers. Okay, so what we've heard, and I think we came into this knowing we didn't want to give healthcare providers additional liability protection if there wasn't something in exchange for that. And so what you have before you today is a two-part proposal when it comes to healthcare providers. We know that 80 to 90% of healthcare providers are at medical-based or medical care facilities, and the amendment that came over from the House gave them some broadened immunity. And so we want to make sure that those healthcare providers that are getting that broadened immunity also have to agree to serve both those that are vaccinated and unvaccinated. And I think we certainly agree on that position, or I think we do. But if they're not willing to provide services to those that have been vaccinated or not vaccinated, then we don't want to provide that expanded liability immunity language that was offered on the House floor. So what we have done in this balloon is we have divided the language when it comes to health care provider immunity to where we have those that are getting the new language. They have to provide care. And then we have the old language that's been in place for a couple years now, and we're not changing the status on that, if that makes sense. So kind of two-part. And if we want, we can have Natalie walk us through how she took that idea that we came up with, House leadership came up with, in after visiting with the president. She can walk us through how she made that happen in this balloon amendment.
Mr. Chairman. So if you look on page 9 there, we kept subsection A intact there, which, you guys have been referring to as the expanded liability. And then we added the provisions that new expanded liability only is provided for healthcare services that are provided at a medical care facility. And then in paragraph B there, we make that new expanded liability provisions. We say that those don't apply to healthcare providers employed by or providing healthcare services at a medical care facility if they deny healthcare services to someone at that medical care facility based solely on their COVID-19 vaccination status. And then that new paragraph 2 there is what the old version of the liability immunity provision looked like. And that new paragraph will apply to healthcare providers that are not employed by or providing healthcare services at a medical care facility. And then because of the changes we made, Jason and I thought it was prudent to kind of change the applicability sections to make very clear that these new provisions in A1 apply from the effective date of this act going forward, and then they will expire on January 20th of 2023, same as the other provisions will apply. And we made that change both in 605503 and in the retroactivity provision in 605508.
And this is your committee now,
Oh,
I think.
that's right. Thank you, Chairman Patton. Well, my first question is, has the Senate leadership seen this language or just the concept of what the proposal is?
The Senate leadership has, I can't speak for the entire leadership, but I know the chief of staff for the president has it, and he was talking, he was going to get it to the president. And that was
So I don't have confirmation that,
hour and 15 minutes ago.
so I don't have confirmation that Senate leadership has seen it yet.
Okay.
But having said that, I do want to thank the House for coming our way in the Senate. It has been the Senate's position since we first met on Monday regarding protecting people's choices and their decision on the COVID-19 vaccine and getting access to medical services. That was our first proposal on Monday. So it's we're thankful to see that the House is moving that direction.
Absolutely. And again, we've just been trying to figure out how to make it work with the new language. And so I hope this accomplishes that.
So with that, let us stand at ease for a few moments to consider this, and
I just want to make sure that
if there are
Seth
other
doesn't have questions.
questions,
They've not-
sure. Oh, I think it's appropriate now.
Thank you, Madam Chair. First, let me make sure it's clear that any suggestions I might have made about pay-to-play politics do not apply to this bill. Those remarks were solely directed to the prior piece of legislation that we discussed. However, the concept of changing from, let me make sure I use the words correctly, damages, if you will, that were a direct response to the COVID-19 public health emergency to a broader immunity based upon events that arise out of or relate to COVID, and I'm paraphrasing. But is that language that we heard or discussed anywhere in our committee, Mr. Chairman?
We did not hear that in our committee. As you'll recall, that was offered on the House floor, and we debated. I assume there was a debate over that on the House floor, and then it became part of Senate Bill 286 as passed out of the House. So that's the House position.
And if I recall correctly, even though this is a Senate bill, there wasn't any Senate hearing where a discussion of broadening the scope of this immunity took place. Was there, Mr. Chairman?
No, we actually 286 was a bill that we had from early last year, also related to COVID and the state's response to it. But it was we had taken care of those provisions in a different bill, so it was an empty shell in our committee, and so we used that shell to put this content into.
And so, as best we can determine, there has never been a hearing in this legislature on the concept of broadening the scope of this immunity. Has there, Mr. Chair?
No, the only debate that I'm aware of was on the House floor.
And so where then did the idea come from that there was some need to broaden the immunity as it relates to COVID? Where did that whole idea come from?
So while we were, Madam Chair, while we were after we'd heard the bill, the underlying bill in committee prior to working it, and I can't for sure tell you who, someone on behalf of I believe the Hospital Association sent some language in an email that they wanted me or us to consider that language, but at the time the bill was moving forward, and so I did not bring it to the full committee for consideration.
That does refresh my recollection, Mr. Chairman, because I know that the Hospital Association was courteous enough to provide me with a heads up that they were asking for this special immunity for their members. Although I was told by a different lobbyist for the Hospital Association earlier this week that this was not their request. Do you have any information that this request came from anywhere other than the Kansas Hospital Association?
I do not have any other information indicating it would come from someone else, but I don't want to put anyone on the hook without confirming it.
Right, and I'm not trying to say that there may not be things that you and I don't know about, but I'm just trying to kind of find out the origin of where this came from. And the reason that I ask these questions, Madam Chair, is I'm trying to figure out why we need this. Can anyone on this committee explain to me why we need to broaden the immunities for hospitals?
Go ahead, Representative Ralph.
Mr. Chair, you look like you were about to speak, and I don't want to intrude upon that. The direct answer is I don't know from someone, but I will give you a guess from reading the language of what I would look at it as having done some defense work in many years past. I might look at this with the consideration of when we started out through this pandemic, and as we were addressing some of these issues, there were concerns that you might directly be impacted in the care you were providing someone with COVID-19, either specifically in regard to their care or someone else. I suspect in looking at this that we may have gotten to a point in time where the delivery of care or the manner in which you were required to deliver care may have impacted other operations within a facility or within a hospital, such that it would not have potentially might not have been considered directly being impacted by the COVID-19, but on a tangent or as another part of the facility that either through staffing or availability of staffing or availability of type of care to be provided, that you did have an impact on someone else who needed care, but because of some other care being provided for COVID-19, it might not have been considered a direct impact. This is a guess on my part. If I were being put on the spot, I could see there being a distinction between directly related as opposed to the language here arising out of or directly related. That's probably the best I can do under the circumstances, is that there could be. Thank you. Thank you, Madam Chair.
Madam Chair, just to provide the language that was sent to me, along with it, it said that the rationale was this more accurately reflects how COVID has impacted healthcare decisions throughout COVID on behalf of the providers.
If I may return then, are you at liberty, Mr. Chair, to tell us the source of whatever it is you just read to us?
It was an email between the revisor's office, me, and representatives of the Hospital Association.
Madam Chair, if I might provide my speculation as to what motivated this change, I think it was because somewhere, some member of the Hospital Association was afraid that a hospital was going to get sued in relation to the failure to administer ivermectin or hydrochloroquine, and that what the concern was that hospitals might get sued by folks who have their good faith belief that alternative methods of treatment of COVID are more efficacious than the conventionally accepted methods. And further, that there was concern that folks who had religious, moral, scientific, or philosophical objections to vaccines in general and the COVID vaccine in particular were contemplating litigation of some fashion against hospitals. And even though I believe the original language, which was a compromise and was negotiated 2 years ago between members of the legislature, the governor's office, the trial lawyers, the hospitals, etc., were sufficient to provide immunity for those types of claims, that at least some members of the hospital association were not comfortable, and they wanted more insulation from claims by folks who look to ivermectin, hydrochloroquine, and are sometimes referred to generically as anti-vaccination people. Now, that's my speculation. But the reason I'm trying to find out is, if we're going to make a policy decision like this, we need to have a good reason. And I like the people at the Hospital Association. I think I'm lucky to live in a town that has excellent hospitals, and I want to keep it that way. But no matter how much I may like somebody, I want to have good reasons to adopt policy. And I have yet to hear any good reason for this expansion of immunity. And that's what I'm looking for, is what is the good reason to disrupt the status quo, which has served us well for the past 2 years. And so far as I know, I may have heard one story somewhere now about a COVID-related lawsuit that either has been or is about to be filed. But other than that, there haven't been any. So I'm just trying to figure out, why are we needing to do this?
Madam Chair, I would just point out that those concerns were not, at least I did not read that into my correspondence with the Hospital Association. The reason I've been advocating for it is it was offered on the House floor. It was a voice vote. It wasn't even roll called because it was overwhelmingly in favor of adding this language, and it passed 102 to 17 out of the House to add that language. And certainly, I believe my role, being on conference committee as a negotiator on behalf of the House, is I advocate for the House position. And it may be something I like or don't like. My role is to advocate on behalf of the House position. And it was often we don't have 86% of people vote one way or the other. And in this case, it was a really strong vote. And so that's why we have advocated for this language.
Committee, are there other questions regarding the House Section 5? I don't want to proceed too far along the way until we have our third conferee back. So we can stand at ease for a moment.
Madam Chair, could I suggest, while we're at ease, that perhaps we stand at ease for about 5 minutes? That way I could step out and consult with some people who may have some expertise in these areas, which might avoid and agree to disagree.
That would be fine.
I appreciate that. I'll see you in about 5 minutes. Thank
We
you.
will then be in recess. Let's make it 10 minutes, and we'll do 6:25. Thank you. Thank you, committee and everyone for returning with us after recess. We do have language that I need to confirm that Senate leadership has reviewed and see if they have any further questions. But for now, do we have any further questions about the House Section 5 proposed offer that also includes the balloon amendment that was offered by the House in response to some points the Senate had made about new Section 1? Do we have any questions? Seeing none, then I'm need to stand at ease for just a moment so I can make one phone call. Thank you. Thank you, committee and everyone, for standing at ease and returning. It is the Senate position that we do need some time to take a look at the language now that we have it in writing and to confer with Senate leadership and determine what the Senate response is going to be. But want to thank the House for the offer, and the chambers are back on the floor at 7 p.m. I think you're on at 7:30 and we're at 7. So what we're going to do then is we're going to other conference committees have been meeting while the chambers are on the floor. So that's what I propose we do here as well, since the hour is running late. So, yes.
Well, I was just wondering if we could try to find a room on the 3rd floor. Is the old Supreme Court room the only room available? Well,
So
if you could find a room closer, it'd be more convenient because I think we will have some CCRs on our side, and those have been going fairly quickly. So I don't know that we'll have time to get all the way.
I haven't done any CCRs in a while, so it'll take a while. Even if
I don't believe we have any of our CCRs tonight or yet. So, so it's not you and me arguing with each other. Anyway, I think we will be as flexible and willing to try to get together as possible. So set the time and we'll do what we can. We may just
Appreciate
each
that.
have to wait on each other a little bit.
yes, we don't want to we want to be appropriate with our timing and moving these issues forward. Okay. I wouldn't think it would be before 7:30 if you can't wait to eat dinner. So,
Madam Chair, I promise to stay out of the bars. I will only eat food and soda pop, okay?
So with that, then the Senate leadership is going to take a look at this and determine what the Senate position is here with the committee. And then we are, until it is called again, which will not likely be before 7:30, we are adjourned. Thank you.